a recognized right to be forgotten. The closest thing we have in US privacy law is the publication of private facts tort. Now, publication of private facts tort says that it is an invasion of privacy to publish information that would be highly offensive to a reasonable person and is not of a legitimate concern to the public. And one of the most famous cases is Barber versus Time, which was a case in Missouri where a woman suffered from this disorder, a medical disorder, that no matter what she ate and how much she ate, she still was wasting away. So she's lying in her hospital bed, and one of the photographers from Time Inc. comes in and, despite her protests, takes her picture, and it's published. They called her the starving glutton. And this was, according to the Missouri court, this was an example of publication of private facts. So the fact that someone has a wasting disease was of interest to the public, but not the fact that this specific woman had that disease. And also built into this privacy tort is an exception, again, for freedom of expression. The idea that newsworthiness is going to outweigh sometimes a person's right to, I guess, remain private. So newsworthiness, and there's actually 5 tests for newsworthiness depending on what jurisdiction you land in. But most of them, it boils down to the relevance of that information. And usually the only time something is considered not of a legitimate public concern or not newsworthy is when it's dealing with a morbid fascination in certain things. An example would be certain autopsy photos or things of that nature, things that are pretty gruesome that would be considered private. And other examples of things that are considered of a public concern, so a young lady flashing her breast at a outside concert would be considered newsworthy. Things that are not, on the other hand, is a woman who walked across an air grate and all of a sudden her skirt is blown over her head. That's not newsworthy. But for the most part, the courts have left it up to publishers to decide what's newsworthy. And then if it's not newsworthy, they're punished after, but it's very much in the discretion of the news organization, what's considered newsworthy. And there are also a couple of cases in which the Supreme Court, although not necessarily deciding publication of private facts cases, dealt with statutes that were kind of like the common law of public disclosure of private facts. So we have these line of cases. We have Cox versus Cohen, Florida Star versus BJF, and the Daily Mail case, in which the U.S. Supreme Court has ruled that you cannot punish, the First Amendment will not allow the courts to punish the publication of lawfully acquired, truthful information. And some of the foundation for these rulings is the fact that as Americans, one of our ideals is that the public has the right to know about the workings of government. And that includes these court cases. So if you murdered someone, if you were involved in a rape case, people have the right to know how justice is administered or how things happen or what's going on in their society in general. As long as it's truthful and lawfully acquired, it's considered of the public interest. Also, things that are considered newsworthy, almost anything happening in the public, as well as strange and unusual events. So what's the real conflict here? There's a conflict between what's considered newsworthy here and the fact that some people would like to say, well, I did that 10 years ago, or that happened 10 years ago. I want to be able to rehabilitate my reputation, my image, and if you consider certain things, certain things built into the law already, make allowances for that. So speaking with someone last night, talk about juvenile records. So after a certain age, juvenile records are sealed and closed, and people usually don't have access to what you did that involved you with law enforcement when you were a juvenile. So that's a one way. But if you think about it, we'll say that juveniles haven't fully formed in their mind and they're prone to do crazy things. What we're really talking about here is adults. We're talking about things that adults do that they would no longer want people to have access to. Another question is newsworthiness versus the passage of time. So does the passage of time take away the possible newsworthiness or the public concern with the incident in which I was involved? There were a couple of cases dealing with that already in American jurisprudence. One of them involved this movie called The Red Kimono, a 1931 case. You had Melvin versus Reed, and there was a former prostitute who had left her life of prostitution, but during that time she had been convicted of murder. 13 years later, she's married, she's living in Missouri, and this Red Kimono movie comes out about her life. And she sues, and she says, you know, I have a right to privacy, or that keeping that information private. I'm rehabilitating my image, and there's so much time has passed that people should you should not be able to put out that information about me. And, you know, the court in California actually ruled in her favor based on the idea that you have a right to a peaceful life, but not based on the right to privacy. Now, the problem is Melvin versus Reed has not been followed by other courts after that. We consider the Sidis case. You may be familiar with the Sidis case, the boy genius who was so smart. He graduated Harvard very early, could do all kinds of math problems in his head, and then he disappeared. And they did a story, like a Where Are You Now kind of story. They found him. He was a ticket taker. He had a lowly life. He, you know, lived in a one-room flat. And they wrote a story and published it about him. And he sued. And they said, you know what? You're still newsworthy. It doesn't matter that so many years had passed between when you were this boy genius and your adult self now. You were still newsworthy. People still want to know about your life. So for the most part, under American jurisprudence, the passage of time doesn't take away your newsworthiness. So that's another conflict with this whole idea of a right to be forgotten. And lastly is reactions, the possible reactions from news gathering and news disseminating organizations. I would think that the very specter of just being slapped with a lawsuit would make news organizations reconsider what they have available online. If we consider slap suits in general, how they affect the expression of information, the idea that it costs a lot of money just to defend yourself from lawsuits would make news organizations, particularly those who have information online, reconsider making that information available. And so with respect to all of these things, I think that a right to be forgotten, even in the most limited form, would really conflict badly with our ideas of, or I should say US jurisprudence ideas of freedom of expression and what the press in particular means to the citizenry. If we think about the marketplace of ideas and the idea of the press as the fourth estate and doing for us what we can't do for ourselves as far as collecting and disseminating information, then such a right would conflict badly with those ideals.